Good afternoon. The Subcommittee on Regulatory Reform, Commercial and Antitrust Law shall come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. We welcome everyone to today's hearing on a time to reform oversight of the activities of the Justice Department's Civil, Tax, Environmental, and Natural Resources Division and the U.S. Trustees Program. And I will now recognize myself for a brief opening statement. Welcome to this oversight hearing on 4 of the Justice Department components within this subcommittee's jurisdiction. The new administration creates an opportunity for introspection and reform within the DOJ. This hearing will aid that process by reviewing abuses under the prior administration, determining whether the new DOJ leadership has started to initiate reforms, how far these reforms have progressed, and we'll explore with the DOJ what other reforms would be appropriate. This subcommittee has examined numerous examples of administration lawyers straining the meaning of the statutes to justify activities never contemplated by Congress. For example, Operation Choke Point was a Justice Department-led program to deny merchants like firearm dealers or payday lenders that the Obama administration deemed objectionable access to the financial networks they needed to survive. The DOJ has cited its special authority to issue administrative subpoenas when fighting fraud, and I'm using a quote here, affecting banks. But the claim fraud in Operation Choke Point was far removed from banks, perpetrated ostensibly on the customers of their customers' customers. Furthermore, committee oversight has found that the program was inflicting an unacceptable level of collateral damage on legitimate businesses, whether intended or not, and that damage lingers. And I'd like to know what the DOJ is planning to do to reverse it. In another instance, a New York Times expose revealed that on the eve of an inevitable victory in court, the department abruptly switched courses away from litigation and settled a discrimination case despite vigorous objections from career attorneys within the DOJ. It appears the department settled in order to pay off friends, including a plaintiff's lawyer who was on President Obama's transition team. What can the department's new management do to halt justice fund abuse? Another troubling pattern of the last administration was sue and settle abuse. This kind of abuse occurs when a regulatory agency agrees to settle a lawsuit with a friendly plaintiff, requiring it to implement a desired policy under the cloak of judicial authority, circumventing the normal rulemaking process, and paying both sides attorney's fees. A May 27th report by the U.S. Chamber of Commerce found that in 8 years, the Obama administration welcomed 137 Clean Air Act settlements, far more than the 93 settlements that the previous administration did over a preceding 12-year period. What steps is the DOJ considering to halt abusive sue and settle practices? Additionally, the Tax Division has been defending the Internal Revenue Service in lawsuits arising out of IRS's inappropriate targeting of conservative groups. The Sixth Circuit rebuked the Obama Justice Department Tax Division lawyers for delaying one of the leading cases, saying, quote, "The government is doing everything it possibly can to make this as complicated as it possibly can, to last as long as it possibly can, so that by the time there's a result, nobody's going to care except the plaintiffs." Finally, I'm interested in an update from the U.S. Trustee's Office on its need for funding assistance, the reduction of fraud in asbestos trust, and its oversight of Puerto Rico's bankruptcy processing, filing its May 3rd, 2017 filing. I appreciate the DOJ making witnesses available amidst this transition, and I hope this hearing will help the new management implement reforms by identifying problem areas and solutions. Excuse me. I also look forward to the suggestions of our second panel that has been carefully monitoring DOJ activities. At this time, the chair will now recognize the ranking member of the subcommittee on regulatory reform, commercial and antitrust law, Mr. Cicilline of Rhode Island, for his opening statement.
Thank you, Mr. Chairman. Today's hearing is an important opportunity to conduct oversight into the work of several components of the Justice Department within the subcommittee's jurisdiction. The importance of legislative oversight cannot be overstated. It's a fundamental check and balance that is key to the public's confidence in government, and it cannot be overstated. In less than 5 months, President Trump has fired Acting Attorney General Sally Yates after she informed the White House that National Security Advisor Michael Flynn was a security risk, fired FBI Director James Comey, who was overseeing an ongoing investigation into the Trump campaign's ties to Vladimir Putin, Former National Intelligence Director James Clapper has called this egregious and inexcusable. Refused to disclose his tax returns, breaking with the tradition of presidents from the last 4 decades. Refused to release White House visitor logs. Refused to release documents requested by Congress. Appointed numerous officials with serious and unresolved conflicts of interest to key government positions. Repeatedly attacked the federal judiciary, a co-equal branch of government, eroding trust in our legal system and the rule of law, and took the alarming and extreme step of instructing government officials to ignore congressional oversight requests unless supported by a Republican committee chair. Because my Republican colleagues have shown little interest in examining any of these matters, this hearing is one of the few opportunities that we have to hear from the Justice Department on the issues important to our constituents. Today's oversight hearing concerns the work of civil, environmental, and natural resources and tax divisions, along with the U.S. Trustee program. The civil division is the largest litigating component of the Justice Department. Among its many other responsibilities, it is tasked with defending the president's unconstitutional Muslim travel ban. The president recently lashed out at his own Justice Department, stating on Twitter that it, quote, should have stayed with the original travel ban, not the watered-down, politically correct version, end quote. The editorial board of the Wall Street Journal referred to these comments as, and I quote, reckless on multiple levels, and merely the latest incident in which Mr. Trump, popping off, undermined his own lawyers, end quote. George Conway, the husband of White House counselor Kellyanne Conway, referred to the president's statements as sad, adding that, quote, every sensible lawyer in the White House counsel's office and every political appointee at DOJ would agree with me, end quote. Mr. Conway recently removed himself from contention for the appointment as permanent Assistant Attorney General of the Civil Division, suggesting that the president's toxic conduct and statements have discouraged qualified individuals from serving in this administration. It's important that we hear from the Civil Division on this matter. The Civil Division is also responsible for representing President Trump in lawsuits relating to conflicts of interest and his alleged violations of the Constitution's Foreign Emoluments Clause by profiting from foreign investments in his property, which has not been divested. Together with Ranking Member Conyers, I have co-sponsored H.R. 371, the Presidential Conflicts of Interest Act, to require the President and Vice President to disclose and divest any potential financial conflict of interest. The Environmental and Natural Resources Division is responsible for enforcing the nation's environmental laws to ensure that America's air, water, and lands are clean. Earlier this week, the Trump administration announced that it plans to appoint Jeffrey Bossert Clark, a climate skeptic who represented BP in lawsuits relating to the Deepwater Horizon spill, one of the nation's worst environmental disasters. While he will not testify for today's hearing, I'm concerned that these types of serious conflicts of interest will imperil the Environmental Division's mission. The Tax Division litigates all matters under the Internal Revenue Laws, collecting more each year than its entire budget. It also plays an important role in investigating and prosecuting offshore tax evasion, a significant concern of mine. Every year, U.S. corporations hide trillions of dollars in profits offshore, skirting $90 billion in federal income taxes. In April, I introduced H.R. 2005, the Offshoring Prevention Act, to keep jobs in America by eliminating tax breaks for companies that evade our tax laws by hiding income overseas. I look forward to hearing from the Tax Division on its enforcement efforts to level the playing field for hardworking Americans and small businesses. Finally, the U.S. Trustee program is responsible for promoting the integrity and efficiency of the bankruptcy system. I look forward to hearing from the program about its efforts to combat creditor abuse, particularly the practice of robo-signing and its other initiatives to protect consumer debtors. The American people demand and deserve transparency. It's critical that we hear from the Justice Department on how these matters affect its statutory responsibilities. In September, Chairman Goodlatte noted that this hearing, and I quote, is an opportunity to conduct aggressive oversight of these 4 components of DOJ to determine whether they are making decisions to uphold the law or follow the political whims of the administration. I agree, and I thank the witnesses for appearing today and look forward to your testimony. With that, I yield back, Mr. Chairman.
Thank you, Mr. Cicilline. Chair now recognizes the chairman of the full Judiciary Committee, Mr. Goodlatte of Virginia, for his opening statement.
Mr. Chairman, thank you, and I second your remarks about the need for reforms at DOJ. I'm very pleased that already a major reform is in place. Yesterday, Attorney General Sessions announced a ban on payments to non-victim third parties in Department of Justice law settlements. I applaud the Attorney General's action. The new Justice Department's respect for the separation of powers stands in stark contrast to the behavior of the Obama administration officials who used their positions to funnel billions of settlement dollars to their political allies. The committee will continue working to pass this bipartisan Stop Settlement Slush Funds Act of 2017, which would ban this practice permanently. Additional reforms are also needed. The Department of Justice did not just force settling defendants to pay non-victims. In 2013, a shocking New York Times expose revealed that the Obama administration bilked over $1 billion from the taxpayer-funded Judgment Fund and handed it to special interests. The vehicles for this giveaway were parallel, weak cases alleging bias by the Department of Agriculture. The Times described how after a succession of Department of Justice legal victories, including in the Supreme Court, political appointees engineered a stunning turnabout. They committed $1.33 billion to compensate thousands of Hispanic and female farmers who had never claimed bias in court. The deal was fashioned in White House meetings despite the vehement objections of career lawyers who had argued that there was no credible evidence of widespread discrimination. The government's statistical expert from UC Berkeley told the Times regarding the parallel Keeps Eagle case, quote, "If they had gone to trial, the government would have prevailed. It was just a joke. I was so disgusted. It was simply buying the support of Native Americans," end quote. The Keeps Eagle settlement was based on the plaintiff lawyer's self-serving estimate that there were 19,000 claimants. Plaintiff's attorneys collected $60.8 million in attorney's fees. Just a year before, the lead plaintiff's attorney, Joseph Sellers, had served on President Obama's 2008 transition team. In the end, there were just 4,400 claimants, fewer than even the government had estimated, and $380 million left over. This was taxpayer money, but instead of demanding it back, DOJ agreed to direct it to non-victim third parties. This troubled the presiding judge, who wrote, and I quote, "Although a $380 million donation by the federal government to charities might well be in the public interest, the court doubts that the judgment fund from which this money came was intended to serve such a purpose. The public would do well to ask why $380 million is being spent in such a manner," end quote. On May 25, 2017, I wrote the Attorney General alerting him to a potential opportunity for the department to recover the $380 million for taxpayers. I look forward to discussing remedies for the larger issue of judgment fund abuse. Overreach is not limited to the executive branch. District court judges are issuing preliminary injunctions outside of their jurisdictions and for the protection of non-parties. According to a forthcoming article in the Harvard Law Review, this is a recent development not in accord with traditional practice. The traditional view was that court injunctions restrain the defendant's conduct vis-a-vis the plaintiff, not vis-a-vis the world. Nationwide injunctions trample the sovereignty of sister courts. They also create a shop till the statute drops problem. Opponents of government action can lose in 93 judicial districts, win one preliminary injunction in the 94th, and then government action can be stayed nationwide despite it being upheld everywhere else. Such perverse results might be avoided if the Department of Justice insisted on the original understanding that courts do not have authority to issue such sweeping injunctions. There are many additional issues to cover. This hearing is one of a series that the committee is holding on the Justice Department to identify areas that are in need of reform. I want to thank our witnesses for their participation here today, and I look forward to hearing their thoughts on restoring the Justice Department to its proper role. Mr. Chairman, I yield back.
Thank you very much, Chairman. It's my understanding Mr. Conyers will submit a statement for the record, and Mr. Johnson has a brief opening statement in lieu of Mr. Conyers, so we'll recognize the gentleman from Georgia.
Thank you. I thank the chair, and I must recognize the fact that we are in the Trump administration now. The Obama administration has gone bye-bye. The need for oversight of the Obama administration has ended back on January 20th, over 100 and some odd days ago. And so now it's time to do oversight into the operations of the Trump administration. And that is the focus of this hearing, and with that, I will yield back.
Thank you very much. I'll now actually, I think we need to swear in our witnesses. So, gentlemen, if you would please rise. Do you swear that the testimony you're about to give before the committee was the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect all witnesses have responded in the affirmative. Y'all may be seated. I'd now like to introduce our distinguished panel of witnesses. Chad A. Riedler, if I'm pronouncing that right, was appointed Acting Assistant Attorney General for the Civil Division on January 30th, 2017. Prior to joining the department, Mr. Riedler was a partner at the Jones Day Law Firm, where he handled complex civil and criminal litigation matters with an emphasis on appellate litigation. Mr. Riedler is a recipient of the Marshall Memorial Fellowship and previously served as a volunteer for Lawyers Without Borders, training Kenyan lawyers in Nairobi. Mr. Riedler earned his bachelor's degree and his JD with honors from the University of Michigan. Following law school, he clerked for Judge Alan Norris of the U.S. Court of Appeals for the Sixth Circuit. Welcome, Mr. Riedler. Jeffrey H. Wood was appointed Acting Assistant Attorney General of the Environment and Natural Resources Division on January 20th, 2017. Prior to his appointment, Mr. Wood served as environmental counselor for U.S. Senator Jeff Sessions and as the Republican staff director for the U.S. Subcommittee on Clean Air and Nuclear Safety in Water and Wildlife. Mr. Wood has also worked in private practice, both as an environmental and energy lawyer and as in-house counsel for a transportation company. Mr. Wood earned his bachelor's degree and JD from Florida State University. A welcome to you as well, sir. David H. Hubbard was appointed Acting Assistant Attorney General of the Tax Division in January of 2017. He was previously Tax Division's Deputy Assistant Attorney General for civil trial matters. Mr. Hubbard has vast experience with the Tax Division overseeing litigation functions and the operations of the 6 regional civil trial sections, the Court of Federal Claims Section, and the Office of Civil Litigation. He also served as a trial attorney in both the Civil Trial Section and the Appellate Section, covering various regions of the country. Mr. Hubbard earned his bachelor's degree in accounting from the University of Arizona and his JD cum laude from the University of Pennsylvania Law School. Welcome, sir. Mr. Clifford White III has served as director of the U.S. Trustees Program since 2006. Mr. White has more than 30 years in federal service, and most of his tenure has been with the United States Trustee Program, including formerly as a deputy director and an assistant United States trustee. Prior to joining the program, Mr. White served as a Deputy Assistant Attorney General within the Department of Justice and as official at 2 other federal agencies. He's been recognized with an Attorney General's Award for Distinguished Service and was conferred the Presidential Award of Meritorious Executive in 2016 and Distinguished Executive in 2009. Mr. White earned his bachelor's degree and his JD with honors from George Washington University and the George Washington University Law School. So, gentlemen, each of you have prepared and presented with us a written statement, which will be entered into the record in its entirety. I ask each witness to summarize his testimony in 5 minutes or less, and to help you stay within that, there is a timing device in front of you. The light will switch from yellow to green, indicating it's time to speed up, and you have 1 minute to conclude your testimony. When the light turns red, it indicates that your time has expired, so please wrap it up promptly. So, we'll get started with Mr. Riedler. You're recognized for 5 minutes, sir.
Good afternoon, Mr. Chairman, Ranking Member Cicilline, and members of the subcommittee. Thank you for inviting me to testify this afternoon about the work of the Civil Division of the Department of Justice. I was honored to join the division on January 30th of this year. It is a privilege to lead the division, and I appreciate the opportunity to discuss with you the important work we are doing, as well as to discuss our budget and resource needs for fiscal year 2018. The Civil Division is made up of more than 1,350 career employees, including more than 1,000 attorneys. Each year, the division handles tens of thousands of cases that involve billions of dollars in claims and recoveries. Even in my relatively brief tenure, I've been highly impressed by the capabilities and professionalism of our attorneys and support staff. The division has the privilege of representing the United States, its agencies, members of Congress, cabinet officers, and other federal employees. Chief among our duties is defending and enforcing various federal programs and actions. In so doing, the division routinely confronts significant policy issues, often with constitutional dimensions. I'd like to highlight a few examples of the significant and varied work done by the talented and dedicated public servants in the division. First is national security. Defending our nation is one of the highest priorities of the department and the division. The division's efforts to promote national security interests include defending lawsuits against government officials arising out of efforts to protect national security, defending policies and procedures related to the security of our borders, such as screening procedures for individuals entering the United States, defending against habeas petitions filed by individuals detained at Guantanamo Bay, defending against challenges to surveillance activities conducted by the National Security Agency, and protecting against the disclosure of national security or classified information in the context of civil litigation. Second is defending immigration actions. The division defends and prosecutes civil immigration matters in federal court, including actions challenging an order of removal. The division also defends numerous cases brought by known or suspected terrorists and convicted criminals attempting to acquire immigration benefits or avoid removal. The division also works to prevent known or suspected terrorists from becoming naturalized citizens or to revoke such naturalizations. And third, let me highlight our work in the area of fraud and consumer safety. The division takes legal action against conduct that threatens the health or safety of American consumers, such as misbranding or adulteration of drugs, and against conduct that seeks to defraud consumers or wrongly deplete the federal fisc. We vigorously pursue false claims that target federal health care programs. The pharmaceutical industry continues to account for part of the division's healthcare fraud recoveries. In addition, the division has put a special focus on elder fraud issues and has addressed both consumer fraud schemes targeting the elderly as well as fraud targeting medical services for the elderly. In each of the last 7 fiscal years, the government's healthcare fraud recoveries have equaled or exceeded $2 billion. The division's efforts to include targeting fraud that contributed to the 2008 financial crisis. In the last year, the division has recovered nearly $1.7 billion in losses from financial institutions that arose out of failed mortgages. The President's fiscal year 2018 budget request seeks 1,140 positions and $291,750,000. While consistent with prior budget requests in many respects, the proposed budget includes a request for an increase in funding for immigration litigation. These resources are necessary to maintain the superior legal representation services provided by the division. We hope the House and Senate will fully fund the request. In closing, let me say it is an honor to work in the Civil Division and to participate in the important and challenging work my talented colleagues perform on a daily basis. Mr. Chairman, I look forward to addressing any questions you or members of the subcommittee may have. Thank you.
Thank you very much, and well within the time limit. Mr. Wood, you're recognized for 5 minutes.
Thank you, Representative Farenthold. Mr. Chairman, thank you. Ranking Member Cicilline and members of this subcommittee, thank you for the opportunity to discuss the vital work of the Environment and Natural Resources Division, or ENRD. I currently serve as the Acting Assistant Attorney General for ENRD, where I have the privilege of leading the nation's premier team of environmental lawyers, paralegals, and staff. I'm also proud to be part of the department-wide team led by Attorney General Jeff Sessions, for whom I worked when he was a senior member of the Senate Environment and Public Works Committee. On Tuesday, the President announced his intent to nominate Jeff Clark to be our next Senate-confirmed AAG. We look forward to welcoming Mr. Clark back to ENRD, where he served from 2001 to 2005 as a Deputy Assistant Attorney General. Over more than a century, ENRD has protected the country's air, land, and water, safeguarded the rights and resources of Indian tribes, and promoted responsible stewardship of America's wildlife, natural resources, and public lands. As detailed in my written statement, the division's record of legal excellence continues to the present day. Looking forward, I believe ENRD is key to the successful implementation of President Trump's new directions for our nation, including his call for an America First energy policy, a major reduction in regulatory burdens, particularly for agriculture and manufacturing, and rebuilding our nation's infrastructure, while at the same time protecting the environment. To guide our work, I have emphasized 4 primary goals for ENRD at this time. First, we will pursue our core mission of protecting clean air, clean water, and clean land for all Americans through the vigorous enforcement of statutes and regulations and the defense of the lawful actions of our client agencies. Fundamentally, this is about respect for the Constitution and laws passed by Congress. As this subcommittee is aware, ENRD is representing the United States in many cases involving agency actions now under review or reconsideration by the new administration. Agencies have inherent authority to review past decisions and to revise, replace, or repeal a decision to the extent permitted by law and supported by a reasoned explanation. As Justice Rehnquist once wrote, "A change in administration brought about by the people casting their votes is a perfectly reasonable basis for an executive agency's reappraisal of the costs and benefits of its programs and regulations." In these kinds of cases, our aim is to avoid unnecessary litigation, support the integrity of the administrative process, and conserve the resources of the courts, the agencies, and other litigants. Second, a key goal is to effectively support and defend the infrastructure decisions of our client agencies. For example, ENRD is vigorously defending vital infrastructure projects today, including the Dakota Access and Keystone XL pipelines, as well as many highway, port, and other projects of importance to communities around the nation. Third, we will work cooperatively with the states and Indian tribes to achieve shared environmental goals. Many of the laws entrusted to us give a primary role to the states and tribes, and we aim to keep that important principle at the forefront of our minds as we fulfill our mission. In this regard, I have greatly appreciated the positive outreach from a wide range of stakeholders, especially our state partners, during the first 4 months of my tenure at ENRD. State Attorney General offices and state environmental officials have reached out or visited to share their perspectives about a broad range of issues. The Environmental Council of the States, the Association of Air Pollution Control Agencies, and other state groups have afforded me an opportunity to visit with their members to hear about their concerns and priorities. On many occasions, when discussing a matter that is taking place in a state, I have asked our attorneys a straightforward question: what does the state have to say about it? Fourth, we will accomplish our work as efficiently and effectively as possible, keeping in mind that every tax dollar we are given must be put to good and appropriate use for the American people. For fiscal year 2018, our division has requested appropriations of approximately $115.6 million. Within that funding level, we also seek one proposed budget enhancement of approximately $1.8 million for additional attorneys and staff to support land acquisition and related efforts to secure the southern border of the United States. In closing, let me say again that I am proud of our team at ENRD. In just the last few months alone, the division has obtained a record-breaking monetary penalty in a criminal vessel pollution case, prosecuted multiple cases involving renewable fuels fraud, brought significant new actions involving violations of the Clean Air Act, and successfully intervened to stop illegal wildlife trafficking. These are just a few examples of the important work that ENRD lawyers, paralegals, and staff do every day on behalf of the American people. I appreciate the opportunity to participate in this hearing and would be happy to address your questions. Thank you.
Thank you very much, sir. Mr. Hubbard, you're recognized for 5 minutes.
Thank you, Chairman Farenthold, Ranking Member Johnson, members of the committee. Thank you for this opportunity to appear before you today to discuss the Tax Division's important work. The Tax Division's mission is to enforce the nation's internal revenue laws fully, fairly, and consistently in federal and state courts throughout the country. We do so through 2 types of litigation: civil investigations and cases, and criminal investigations and prosecutions. In this litigation, we aim to promote voluntary compliance with the nation's tax laws by deterring those who would avoid paying what they owe and promoting the sound development of law by carefully considering the legitimate issues raised in our cases. In each and every civil case, the Tax Division's attorneys strive to collect the proper amount due and owing, no more and no less. In each and every criminal case, Tax Division's attorneys authorize and prosecute cases after determining there's a reasonable probability of conviction. In recent years, the division typically has 6,000 civil cases in various stages, handles hundreds of civil and criminal appeals, and authorizes between 1,300 and 1,600 criminal tax investigations and prosecutions, which are then handled by the division's prosecutors in the United States Attorney's offices, or some combination of the two. The Tax Division currently has approximately 350 attorneys and 145 administrative professionals handling all this work. I'm honored to be able to represent them here today. They serve the American people with great skill and dedication. Among the division's top priorities is civil and criminal employment tax enforcement. Employers have a legal responsibility to collect, account for, and pay over what they withhold from their employees' wages. Amounts withheld from their employees' wages represent nearly 70% of all revenue collected by the Internal Revenue Service. Unfortunately, billions of dollars of employment taxes go unpaid. When employers fail to comply with their obligations, they are stealing not only from their employees, but also the U.S. Treasury, as well as gaining an unfair advantage over their honest competitors. Since 2014, the Tax Division has obtained more than 70 permanent injunctions against delinquent employers and pursued criminal investigations and prosecutions against those who willfully fail to comply with their obligations. These cases send a clear message that the conduct will not be tolerated. The Department remains committed to addressing this serious issue and leveling the playing field for all employers. Addressing offshore tax evasion remains a top priority in the Tax Division and the Department. Since 2008, the Department has criminally charged more than 130 U.S. taxpayers who used foreign financial accounts to evade their tax and reporting obligations, and more than 40 individuals who facilitated that criminal conduct. In August 2013, the Department announced the Swiss Bank Program, which provided a path for Swiss banks to resolve their potential criminal liabilities in the United States. By January 2016, the Department had executed 78 agreements with 80 Swiss banks and financial institutions, collecting more than $1.3 billion in penalties. The information we received from that program provides substantial insight into the methods used to facilitate offshore tax evasion. Along with the IRS, we're reviewing the information to pursue ongoing and new criminal tax investigations and to support civil tax enforcement efforts. According to the Internal Revenue Service, it has received more than 55,000 voluntary offshore disclosures and collected more than $10 billion in taxes, interest, and penalty. Another significant area of concern is identity theft and stolen identity refund fraud, commonly referred to as SIRF, which involves stealing personal identifying information and filing fictitious tax returns to claim refunds. Through March 2017, the Department authorized more than 1,400 SIRF investigations involving more than 2,400 subjects and authorized more than 1,100 prosecutions of more than 2,200 individuals. While the ultimate goal is to stop fraudulent refunds at the door, and that ability is improving, the Department will continue to work with its law enforcement partners to prosecute these cases and hold those who engage in this conduct accountable. I've only touched on a few of the many issues being litigated by the Tax Division. Through our civil and criminal litigation, we send a clear message. When individuals or entities engage in misconduct to avoid or evade their legal tax obligations, the Tax Division will use all available tools to firmly but fairly hold them accountable. In conclusion, I'm honored to represent the bright, honest, and truly dedicated public servants working at the Tax Division, and I'm happy to answer any questions you may have.
Thank you very much. We appreciate your testimony. I know your job is very taxing. Yeah. Mr. White, you're recognized for 5 minutes. Could you turn your microphone on and get real close to it? We bought the budget mic, so you need to be real close so we can hear you.
Thank you for the reminder. Good afternoon, Mr. Chairman, Ranking Member, and members of the subcommittee. I'm grateful for the opportunity once again to report to you on the activities of the U.S. Trustee Program and to discuss our success in achieving our mission to promote the integrity and the efficiency of the bankruptcy system for the benefit of all stakeholders, debtors, creditors, and the public. As recited in greater detail in my written testimony, we perform a wide array of administrative, regulatory, and enforcement activities that are essential to the proper functioning of the bankruptcy system. Basic case administration depends upon our appointing and overseeing 1,400 private trustees who administer more than $10 billion in assets annually. Protecting the rights of all stakeholders relies in significant measure on the neutral United States trustee enforcing the law as the law was written by the Congress. And ferreting out fraud and abuse depends upon the program serving as the vigilant watchdog of the bankruptcy system. Since our last oversight hearing, the USTP has continued on a steady path of vigorous and balanced enforcement of the bankruptcy code. Each year, we take more than 30,000 formal and informal civil enforcement actions and make about 2,000 criminal referrals to our law enforcement partners. A majority of these actions curb debtor abuse, but a cornerstone of our efforts also has been consumer protection. For example, we remain vigilant in policing mortgage servicer and other creditor misconduct. Earlier this year, we filed 2 additional settlements with Chase Bank to resolve violations involving improper billing and noticing of 16,000 accounts in bankruptcy. As remediation, Chase is providing about $2.8 million in payments, refunds, and credits to affected homeowners. Several months ago, we also launched an initiative to address professional misconduct by consumer debtor lawyers, including those who operate across district lines and advertise on the internet. 2 national bankruptcy firms ceased operations as a result of enforcement efforts, and we're litigating and investigating other cases. In business bankruptcies, we frequently are the only party to uphold statutory mandates to restrain management, professionals, and other parties. In the Jevick Holding Corporation case, for example, we litigated on the side of truck drivers who were laid off the day before the company filed bankruptcy. Over our objection, the debtor obtained bankruptcy court approval to pay unsecured creditors, but not the truck drivers whose claims were entitled to higher priority under the statute. Although we lost in the lower courts, our position prevailed in the Supreme Court. Among our new Chapter 11 initiatives, we're reaching out to stakeholders in anticipation of developing guidelines governing our review of fees charged to the bankruptcy estate by financial professionals, including investment bankers. In recent years, the fees of these professionals have grown and even exceeded attorneys' fees in some cases. Similarly, we're revising extant guidelines governing our review of conflicts in the employment of chief restructuring officers. Over the past decade, CROs have been hired more frequently, and the scope of their employment sometimes presents issues of corporate governance and conflicts of interest. Both of these guidelines will bring greater transparency and predictability to the bankruptcy system. In early May, as was mentioned by Mr. Farenthold, the Commonwealth of Puerto Rico filed for debt adjustment under Title III of PROMESA. As in municipal bankruptcies, the courts and the USTP play a more limited role than in corporate reorganization cases. Under PROMESA, we have 2 major duties. 1, to appoint 1 or more creditors' committees that represent the interests of unsecured creditors, including retirees, and 2, to review and object to professional fees. We're taking steps to perform both of these tasks. To achieve our mission, we're requesting an appropriation for fiscal year 2018 of $225.5 million. This is essentially the same amount appropriated in each of the past 3 years. Over 10 years, our budget has increased by less than 2%, and our staffing level has decreased by 14%. We're grateful to this committee for favorably acting on a proposal to increase quarterly fees paid into the U.S. Trustee System Fund. If enacted, it will ensure that appropriations made to the program will be fully offset by revenues. We have achieved our mission in a period of scarce resources by adopting innovative work processes, allocating field staff to perform region-wide and nationwide tasks, and taking other prudent cost-cutting steps. But more than that, the primary reason we have succeeded is the extraordinary dedication of my colleagues in the U.S. Trustee Program. They deserve respect and appreciation for their talent, for their service to the public, and for their noteworthy accomplishments. I'd be happy to respond to any questions.
Thank you very much, Mr. White. As is typical when I chair a committee, since I'm here the whole time, I reserve my questions for last out of respect for other members' time, and gives me an opportunity to back clean up, so to speak. So with that, we'll recognize the gentleman from Florida for his line of questioning first.
Thank you, Mr. Chairman. Mr. Wood, good to be here with a fellow Seminole. I wanted to ask some questions about the mechanism by which the Department of Justice enforces environmental laws. When the Department of Justice is bringing an action under the Clean Air Act, does it require any sort of pre-clearance or permission from the EPA?
First, thank you. Go Knowles. Indeed, we are honored to be able to work in the defense of the nation's clean air laws, and we work closely with EPA. Matters are not brought as a first matter by the Department of Justice. They are first referred to us from EPA, and we continue to work in consultation with them, including in our Clean Air Act cases.
I also want to ask a question regarding your testimony on border security. You've indicated that land acquisition will be an essential component of building a wall on the southern border with Mexico. What would be the time frame for that acquisition?
Thank you very much. So there are approximately 2,000 miles, as you know, along the southern border, 5 border districts. We work closely with the U.S. Attorney's offices in those districts. We have no specific time frame at this point for, and I'd refer you to CBP on specific details related to the border construction. Our responsibility is to make sure that to the extent land acquisition is required, that it's done in compliance with the Fifth Amendment, which we take very seriously.
I also wanted to ask a question. I believe it is of, I guess, a tax question. I'm sorry, a trust question. It was mentioned in testimony that there is misuse of trust laws as it relates to marijuana businesses and their access to bankruptcy laws. If marijuana was no longer a Schedule I drug, but was instead a Schedule III drug, would those challenges continue to persist?
Excuse me again for not pressing the microphone. I'd have to consider that issue further, but as long as something is an illegal asset under federal law, and if it cannot be sold under federal law, then we would take steps to ensure it cannot be administered under the federal bankruptcy law. We recently issued a directive, to put it with regard to the current state of the law, which really restated longstanding policy that we have had in the program to move to dismiss or take other enforcement actions, which among other things protects trustees who otherwise are not allowed to sell an asset. They cannot break the federal law in order to sell an asset to distribute to creditors in bankruptcy. And we also wanted to ensure that we're being made aware of all of the marijuana asset cases that have been filed so that we can intervene and take the appropriate action and be consistent in our enforcement. With regard to which schedule it's on, I'd have to go back and I'd have to do some more research with regard to that. But the basic point is, if it is illegal under federal law to sell an asset, to sell a controlled substance, which you cannot do, or to possess a controlled substance, then we would take action to ensure that the federal bankruptcy code does not provide an avenue to evade those federal laws.
Do we know how much in taxes is paid from marijuana companies in cash?
I do not know.
If we were able to have federal law consistent with state law that allows marijuana transactions to occur, what would we anticipate would be the impact on creditors in circumstances where there's a failed marijuana business and there's outstanding obligations?
I do not know dollar-wise what the size of the marijuana operations are that have come into bankruptcy and so forth. But our job as watchdog of the bankruptcy system is to ensure that the laws as passed by Congress are upheld. And that is why we have taken the position through 2 administrations with regard to marijuana assets. They will not be administered through the bankruptcy system. Trustees will not sell those assets. And yes, in some cases, that means that assets that otherwise would be liquidated by a trustee won't be distributed to creditors. But if the case is dismissed, it simply puts the parties in the same position they would be under state law had there never been a bankruptcy.
Thank you for your indulgence, Mr. Chairman. I'll yield back.
Thank you very much, and we'll now recognize the ranking member of the full committee, Mr. Conyers, the best-dressed man on this panel today.
Thank you so much for the compliment. Ladies and gentlemen, this is an important hearing, and I'd like to begin by asking whoever talked about the Flint water crisis or wants to talk about it to deal with this consideration. Americans deserve access to safe drinking water. What is the Environmental and Natural Resources Division doing to ensure that the Flint water crisis is not repeated in other communities?
Thank you for the question. It's a very important issue.
It is.
I recognize that in recent months, the administration released $100 million to address issues in Flint, Michigan. I know there's important resources that will go to help. It's a bigger national issue. Our mission at the ENRD is to ensure that all Americans have safe, clean drinking water and clean air. So we enforce the laws to ensure that that is provided for. One of our recent cases may be of interest on this point. We worked with the state of Mississippi, MDEQ, to prosecute an individual who had intentionally contaminated local drinking water. And so we take this issue seriously nationwide, and we'd be glad to talk to you or your staff about more details related to our specific work in any other area.
Great. Do any of the other witnesses have any thoughts about what went on in Flint and would like to add to this part of our discussion? Okay. Let's look at the issue of identity theft. And whoever is prepared for some discussion about this, please join in. Criminals have electronically filed tax returns using the stolen identities and personal data of innocent taxpayers to file returns and obtain refunds fraudulently. How substantial or widespread is this problem? And what has the division made, what efforts has the division made to address this issue?
Thank you for raising this issue. It's an important one. I think the department has said from the outset of this problem that we were never going to prosecute our way out of it. And really the best way to address it is to have the fictitious refunds and the false returns stopped at the door. And I think that the Internal Revenue Service has reported that their efforts in that area have improved. I think the commissioner has stated that from 2016, there was a 46% decline in new victims from 2015. So there's some progress being made with the filters and stopping the refunds. With respect to what the tax division is doing, often these are more like street crimes than they are financial crimes. And so we have pushed out the authority to handle these cases to the U.S. Attorney's Office to the greatest extent we can. We have a cadre within the tax division that focus on these cases so that when there is an unusual case or a matter that is unusually complex, we can provide resources to the U.S. Attorney's Office. Where there's a spike in a particular scam in an area, we have attorneys that we can send out there to help in the area, in that particular district. So we've tried to do what we can to make these cases move as efficiently as we can and as effectively. The sentences that the department has been obtaining are significant, and we hope that those who would think about this crime are being deterred from continuing.
Thank you, Mr. Hubbard. Let me turn now for my last question to Mr. Clifford White III, the director of the trustee program. With respect to the $60 fee that a Chapter 7 trustee receives from administering a no-asset case, you note that the United States trustee program supports increasing this fee. Now, it's known that the Chapter 7 trustee administers a bankruptcy case primarily for the benefit of the creditors with respect to investigating any fraud and the availability of any assets. Accordingly, should the creditor pay for this fee and increase Chapter 7 trustees, and for this fee increase for Chapter 7 trustees? What say you, Director White?
Well, Mr. Conyers, our position on that has been, as a general proposition, that the no-asset fee, which is what the $60 is, it's provided in every case, as you said, hasn't been increased for more than 20 years, and as a general proposition ought to be increased. How that can be done in a way that is fair to all stakeholders has been a debate that has been had in Congress for some period of time, so we're not endorsing any particular proposal. I just make one additional point, however, Mr. Conyers, and that is that with regard to most of the trustees, when you say most of the trustees' work is liquidating assets and so forth, in fact, They are dealing with thousands and thousands. 95% of all of the cases that they are assigned, in fact, have no assets. There will be no distribution. But it takes some fair degree of review of the papers filed in the case before they can come to that conclusion. So for so many of these cases that are no assets and that no money goes to creditors at all, that's primarily where the rub comes with regard to the economics of not having changed that $60 fee for more than 20 years.
Thank you very much. My time has expired, and I may send questions to some of you to be added to our record today, and I yield back and thank the chairman.
Thank you very much, Mr. Ranking Member. Since I'm the one left on our side, I'll go ahead and do a few questions myself. I'll start with Director White. There's been substantial press coverage about fraud and asbestos litigation and fraudulent claims made against the Asbestos Bankruptcy Trust. One bankruptcy judge cited a startling pattern of misrepresentation, and that's a quote, by trial attorneys seeking payment from these trusts and from companies in bankruptcy. A former trial lawyer turned whistleblower even stated that asbestos trusts are platforms for institutionalized fraud. Does the DOJ agree there's enough controversy related to fraud against bankruptcy trusts to warrant a review by the DOJ?
I cannot speak for all of the Justice Department, Mr. Farenthold, so let me speak just for the U.S. Trustee Program. It is a fact that there is a lack of transparency in corporate governance in post-confirmation trusts in general. And I've testified on that in the past as well. It was recognized, in fact, by a panel of bankruptcy experts assembled by the American Bankruptcy Institute as a commission to study the reform of Chapter 11. As a watchdog of the system, when you look at post-confirmation trusts and asbestos trusts in particular, it is very clear there is no independent policeman. There is no watchdog for that. Neither the court nor the U.S. Trustee Program have significant jurisdiction post-confirmation. So when you don't have an independent review of any kind of an entity in bankruptcy, including the asbestos trust, then you run certain risks for abuse.
All right, I appreciate it. I've got a lot of questions. I don't mean to cut you short because this is a topic of interest to me, but I do have several questions for Mr. Wood on the Sue and Settle program. As you know, under a process called Sue and Settle, agencies like the EPA and Department of Interior enter into court-appointed agreements with outside environmental groups. These agreements mandate agency actions, reorganize agency priorities and funding, and bypass the laws that allows the public to provide a meaningful input. What do you think the implications of Sue and Settle agreements, given that agencies often end up diverting their focus from congressional priorities are?
Thank you. That's a very important question and an important issue. First, let me say our focus in our division is on defending the lawful regulations and actions of our client agencies. Under my watch, there will be no collusion involving any sue and settle actions whatsoever. And with respect to the longstanding policy of the Department of Justice, we will abide by Attorney General Meese's memorandum. In fact, whenever settlement agreements are presented to my desk, we'll look closely at that to make sure it abides by those requirements.
All right. Now, the other issue with sue and settle agreements is that following an agreement, the taxpayers' hard-earned dollars usually goes to paying for the environmental group's attorney's fees. These expenses can total into hundreds of thousands of dollars per settlement. Do you think we'll be seeing fewer sue and settle cases if the environmental groups filing them could not recover attorney's fees from the government?
Well, I can't comment on any specific legislative proposal, but I can say that it is important to make sure that any payment in any case is based soundly in law. The statutes provide that attorney's fees aren't necessarily owed in every case, and in fact, attorney's fees aren't owed if the position of the agency is substantially justified under the statute. However, that may not have been enforced as closely as we might have hoped it would have been in the past. But certainly, looking at that issue is an important priority, I think, for Congress.
All right. On May 25th, 5th, 2017, Chairman Goodlatte wrote a letter to the Attorney General alerting him to the potential opportunity for the DOJ to recover $380 million in taxpayer dollars that the Obama administration improperly handed to their political allies. This is real money, but the necessary motions would have to be filed quickly. Does anybody on the panel know if a decision has been made on this issue yet?
Thank you, Mr. Chairman. I can address that question. First off, we appreciate the Chairman Goodlatte's letter. And as the Chairman Goodlatte, I think, referenced in his opening remarks, there was a policy issued yesterday by the Attorney General that addresses the topic of payments to third parties. And that's a very important policy that the department will adhere to. It emphasizes that victims in any given case will be compensated according with court order or settlement. But otherwise, any additional dollars will be returned to the public fisc and not paid out to third parties. Now, with respect to the Keep Siegel case, specifically pursuant to longstanding department practice, we don't comment on pending cases, but we're certainly aware of the request from the chairman, and we are reviewing the issue. Thank you.
All right, and one final question on the environment. The Environmental Division is defending a federal land grab relating to the Red River. The Bureau of Land Management has deemed that the Red River bed extends more than a mile into dry land in direct contradiction to the Supreme Court's ruling that said the boundaries follow the course of the stream. Are y'all evaluating whether this legal action serves the public interest of justice? And if the Bureau of Land Management wishes to compensate Native American tribes with land, wouldn't it be better to take the case to Congress rather than private citizens, Mr. Wood?
Congressman, thank you for that question. I'm familiar with the case, the Adderholt versus BLM case. I can't speak to specifics about ongoing litigation that our division is handling, but I can assure you that we're taking a close look at the matter.
All right, I see my time has expired. We'll now recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Mr. Riedler, the Trump administration has reportedly issued an order instructing agencies to refuse to respond to Democratic congressional inquiries or information requests. Is that correct?
Well, thank you for your question. I think that the terms of the order would speak for itself in terms of what the president has issued. Our policy at the department is certainly to, with respect to letters that are issued from Congress, and I see those pretty regularly, that we do attempt to respond to all letters issued by Congress. Otherwise, with respect to oversight responsibilities, we certainly comply with requests from the chairman and then take other matters under advisement.
So you are saying that the Civil Division of the Justice Department will be responding to Democratic ranking members of committees, subcommittees, requests for information, including documents?
Well, no, those are issues that we take under advisement at the department, and
those would be covered by the order issued by the Trump administration not to respond.
Well, the Department of Justice, of course, sets the legal position of the United States, and we'll take all of those requests under advisement, and we'll consider them against the backdrop of governing law and any other principles articulated by the administration.
Will you respond to questions for the record from Democratic members of this subcommittee as part of the record for this hearing?
I'm not sure I understand the question. I'm certainly here to address the questions I can't address. Obviously, I can't comment on pending cases or pending requests.
All right. Earlier today, former FBI Director James Comey testified before the Senate Intelligence Committee that President Trump demanded his loyalty, telling him, quote, "I need loyalty. I expect loyalty." Have you pledged your loyalty to President Trump through communications or otherwise?
Well, like the other members of the department, we've all sworn allegiance to the Constitution, to uphold the Constitution, and that is our guiding principle in terms of cases, in addition to interpreting and applying the law and the facts as they take us in any specific case.
So you've not been asked to swear your allegiance to President Trump?
Again, I'm not, no. The answer is we uphold the Constitution.
Well, thank you. The Civil Division is responsible for all civil immigration litigation, including the Muslim travel ban. Is that correct?
The Civil Division was chiefly responsible for defending the challenges to the executive orders issued by the president, including the executive orders that address travel issues. And I would really like to commend my colleagues, especially the career colleagues at the Department of Justice, who worked extremely hard in defending these cases under challenging circumstances, given the pace of those cases and the number of cases that have been filed. Those specific cases, of course, now are all pending litigation. There are 2 matters before the Supreme Court, and I, of course, can't comment on any specific pending case.
Well, gosh, I was going to find out whether or not you agree that the orders that were issued by the president are indeed travel bans.
Well, is
that true?
The executive orders, the department has taken a very consistent position, are lawful exercises of the president's constitutional and statutory power.
You don't want to go near the travel ban language?
Well, the executive order, I think, speaks for itself.
Has the president's manifestations on Twitter about the orders being Muslim or actually travel bans, has that hurt the department's ability to prosecute its appeal?
Well, again, I can't comment on pending cases. We have 2 cases pending in the Supreme Court where we have vigorously defended the executive orders as lawful exercises of the president's constitutional and statutory authority, including authority granted the president by this body in a host of immigration laws.
Thank you, Mr. Woods. Or Mr. Wood, I'm sorry. President Trump recently announced that the United States will withdraw from the Paris Agreement, stating that the United States would be exposed to, quote, massive legal liability if we stay in, end quote. Leading environmental law experts strongly disagree with this statement. However, UCLA law professor James Salzman notes that President Trump's statement is, quote, not true, end quote, because there is, quote, no liability mechanism under the Paris Agreement, end quote. While Columbia law professor Michael Berger adds that the United States may be more exposed to lawsuits as a result of withdrawing from the Paris Agreement. Do you, Mr. Wood, agree with President Trump?
Thank you, Congressman. We have a very significant role in the division in defending the administration's actions, including defending his actions pursuant to his America First energy policy, and we're actively engaged in those cases. Any questions with respect to the International Paris Accord, I would refer you to the State Department, who's primarily responsible for those issues. But thank you for the question.
Well, let me ask you this. Are you concerned that withdrawing from the agreement may result in increased liability for inaction, as President Berger has warned?
Well, thank you for the question. I think the President's statement stands for itself, and we will continue to vigorously defend all actions of the client agencies who we're honored to serve to the extent those come up in court. Thank you.
President Trump has referred to the international scientific consensus that climate change is real and caused by human activity as a quote, expensive hoax that was created by and for the Chinese in order to make U.S. manufacturing non-competitive. Is that a statement that you agree with?
Well, I would refer you to the administration, the EPA, on the administration's current position on climate change. Our responsibility at the Environment Division is to defend the lawful actions of our client agencies. That includes those actions in the regulatory context under the Clean Air Act, as well as the enforcement of the clean air laws, which we're continuing to vigorously do.
Well, I take it you're not going to share your personal views on these issues.
Thank you, sir. My personal views aren't really relevant to my responsibility to enforce the law
Well, if I
and
ask
the
you,
agency.
though, you're saying that you're going to determine that my questions are not relevant and so therefore not answer them? Is that something that the administration has instructed you all to do?
The gentleman's time expired. We'll let Mr. Wood answer the question, and then we'll move along.
Thank you, Congressman. I respect you and your question. I think it's an important issue. I don't diminish the issue whatsoever. I just would simply say, with respect to the administration's position, that's put forward by EPA and others. My responsibility as the head of the Environment Division at DOJ is to enforce the laws, including the Clean Air Act, and to defend the lawful actions of our client agencies. But I do respect you and the position that others have on that issue. Thank you.
Thank you, sir.
Thank you, Mr. Johnson. We'll now recognize the second best-dressed man on the panel today, the gentleman from Texas, Mr. Ratliff.
Thank you, Mr. Chairman. Thank the witnesses for being here today. I think these are really important issues that we're talking about because I and the vast majority of the constituents that I represent are of the opinion that there have been a number of instances over the last 8 years where the prior administration, the Obama administration, appeared to put politics above the rule of law. There were a variety of cases where we saw the Obama administration appear, in fact, to expressly subvert the will and the intent of Congress and the American people. One of those instances that comes to mind was Operation Choke Point, where we saw that administration target banks that did business with certain disfavored retailers like payday lenders and payment processors, and disfavored industries like gun sellers and coal producers. More broadly, we also saw the targeting of conservative groups by the IRS merely because of their political beliefs. Now, those are just a few instances, but I will tell you that I am optimistic going forward, that we have an opportunity to turn the page and restore accountability and put the rule of law back above politics. I say that because we saw an example of it just this week when the Trump administration announced its decision to halt these settlement slush funds, that is to prohibit the practice of the Obama administration, Department of Justice, of systematically subverting Congress's spending power by requiring settling parties to donate money to various activist groups. Mr. Wood, I want to start with you because you stated in your written testimony, we all know that ENRD plays an important role in enforcing our nation's environmental laws, the Clean Water Act, the Clean Air Act. Knowing that these laws and corresponding regulations could hurt jobs, for instance, in mining and manufacturing, Congress specifically included in Section 321A of the Clean Air Act a requirement that the EPA conduct continuing evaluations of potential loss or shifts of employment that could result. I'm sure that you are aware, and maybe some of my colleagues have already covered this, but there's a case pending in the Fourth Circuit where the Murray Energy Corporation sued the EPA under the Obama administration, asserting that the EPA's refusal to complete that job impact analysis irreparably harmed Murray Energy. The lower court agreed with Murray, noting that it would be an abuse of discretion for the EPA to refuse to conduct that evaluation for the impact that it might have on regulations for the coal industry. In recent arguments before the Fourth Circuit, I understand that the Department of Justice focused largely on procedural issues, arguing that Murray lacks standing and urging that the case be dismissed. But the DOJ also recently filed a compliance plan with the district court, which indicated how the EPA would comply with the law. And I will tell you, I was heartened when I saw the compliance plan because at least in that sense, it represented an effort on the part of this administration that wasn't evident under the prior administration, particularly because this effort, to me, seems consistent with the statements made by Administrator Pruitt and Attorney General Sessions on this issue as well. So my question to you is this. If the Fourth Circuit agrees with the Department of Justice argument that Murray doesn't have standing, is the administration still committed to conducting the jobs impact analysis required under the Clean Air Act?
Thank you, Congressman. I'm aware of the letter. I appreciated receiving the letter. As has been mentioned a few times on this panel today, we can't speak to specific issues in pending litigation. I'm aware of the filing that you mentioned, which was required under the district court's order, and I would refer any questions specifically related to EPA's plans to the EPA. I'm proud of the work our lawyers are doing in all of our full range of cases. We take a close look at the law and the facts to make sure every position we're taking is well-grounded, and we'll continue to do that, and I will commit to keep the committee informed as to any developments that we can share with you about in that case.
Well, I appreciate the comments regarding pending litigation. Quite frankly, we'd rather this not be pending litigation because we'd hope that they'd be willing to comply with the job impact analysis required by law. But let me move on then. 321A of the Clean Air Act uses the term shall, yet this language is being interpreted as a quote-unquote discretionary duty. Can Can you answer for me whether there's additional language that as a member of Congress we could include to clarify that this job loss analysis is required and is not a discretionary duty?
Thank you, Congressman, for that comment. I can't comment on specifics related to the pending case, as we've said, but I would certainly I welcome that input, and we'll be sure to keep this committee informed on the case as it progresses.
That I'll yield back, Mr. Chairman.
Thank you, Mr. Ratcliffe. We'll now recognize the gentleman from Illinois for 5 minutes.
Thank you, Mr. Chairman, and thanks to all of you for being here today. And more importantly, thanks for the work you, and I'm going to extend it to the many people working in your departments do for our nation every day. Mr. Wood, I'd like to start with you. The materials that you submitted to the subcommittee for this morning or this afternoon's hearing state that the mission includes, and I'll quote, promoting national security and military preparedness. In 2015, the Department of Defense released a report on the national security implications of climate change, finding that climate change will aggravate problems such as poverty, social tension, environmental degradation, ineffectual leadership, and a weak political institutions that threaten stability in a number of countries. During his confirmation hearing, Secretary of Defense James Mattis similarly observed that climate change is a challenge that requires a broader whole-of-government response. And he went on to say that he would ensure that the Department of Defense plays its appropriate role within such a response by addressing national security aspects. So my questions for you are, what's your take of the assessments of the Department of Defense under both now the Obama and Trump administrations that climate change is a national security threat? And how will that, or should that, affect the work you're doing in your department?
Thank you, Congressman. As I mentioned earlier with respect to a similar question, our role at the Environment and Natural Resources Division is to defend the lawful actions of our client agencies and to enforce the laws, including the Clean Air Act, which we're continuing to do. With respect to any issues related to the administration's position on international issues or on climate change, I would refer you to the State Department and to EPA.
But if I can, to the extent that the law and regulations are requiring actions of our government and pursuing, there's a difference perhaps of positions from the White House and the Department of Defense. How will that affect what you're trying to do?
So our responsibility is to look at the law, look at the facts, look at the actions that our client agencies take in light of what the statutes that Congress has passed would require, and where the actions of the agencies are lawful and appropriate to defend those vigorously in court, and that's what we're doing. I would note that the current administration, with the President's directive on an America First energy policy, is taking a fresh look, doing a review or reconsideration in some cases of previous regulations. Those kinds of reviews happen in the beginnings of virtually every administration, and the work of our lawyers right now includes assisting with those efforts to ensure that the agencies have the appropriate time to do a thoughtful review consistent with the Administrative Procedures Act, and to ensure that they, to the extent they make changes in positions, that those are vigorously defended in court, and we're honored to be able to work with our client agencies on those endeavors.
Thank you, and I'll just say, to the extent that the laws were drafted with the intention of ensuring the sustainability of our environment and to ensure our national security, I look forward to you enforcing them or defending them as best as possible. Mr. Riedler, if I can turn to you, you said in your opening statement asked for a significant budget increase to add more lawyers. What would those lawyers be doing?
We have a request for 20 additional lawyers in our Office of Immigration Litigation. That's the office that handles both district court and appellate court litigation proceedings that help enforce the litigation or the immigration laws of the United States, working with DHS and other federal partners.
Okay. Recent reports have talked about the administration unable to fill senior roles in 93 U.S. attorney vacancies nationwide. Are you having a challenge bringing on lawyers? Do you see it being difficult to bring lawyers on, those additional lawyers you're talking about?
I'm not sure which specific lawyers you're referring to. U.S. attorneys are not hired through the civil division, so that would not be something that we have oversight over, but we have some new lawyers joining us in the next few weeks.
And you as far as recruiting, has it been a challenge finding lawyers willing to come to the administration in the current environment?
I'm not aware of challenges that we have for recruiting. As the political leadership, we aren't directly involved with recruiting. There are a lot of rules with respect to hiring that we adhere to. But my general sense is that when there are openings, there are many lawyers who are interested in working at the Justice Department and specifically in the Civil Division.
Okay, great. And as my time is about to expire, I will yield back.
Thank you very much. And if the ranking member will indulge me for 2 quick questions I wanted to follow up on that was asked. Mr. Ritter, you said you requested funding for additional lawyers to handle immigration cases. Is the source of delays in immigration the Justice Department? Is it lack of judges? I assume you need more judges because there's a backlog. I'm sorry, more lawyers because there's a backlog. Even with more lawyers, is there not backlog also for shortage of judges to adjudicate these issues?
Yeah, so with respect to the Civil Division specifically, our lawyers handle the immigration cases really at the end of that process when cases are appealed from the Board of Immigration Appeals to the federal courts of appeals. But on the front end of that process with the Executive Office of Immigration Review, my understanding is there is some backlog there and that there have been separate requests to add judges to expedite that process or to move those cases ahead, which would then, on the back end, create additional work for the Civil Division in handling any appeals.
Is your shortage of lawyers creating delays in adjudicating these cases as well, where you're having to ask for continuances and things because of lawyer workload?
I think currently we are doing a pretty good job of staying on top of those cases. We have about, on average, 7,000 appeals per year, but our capacity would increase and we'd be able to handle additional cases, obviously, with additional funding.
Thank you. I appreciate your indulgence. We'll now recognize the gentlelady from Washington for her line of questioning.
Thank you so much, Mr. Chair. I'm sorry I missed some of this hearing, but I did read the testimony, and I appreciate you all being here. I wanted to focus a little bit of attention on environmental regulation and specifically direct some questions to you, Mr. Wood. The Environmental and Natural Resource Division is responsible for litigating environmental and natural resource cases on behalf of the United States, including those that arise under the Clean Air Act, the Clean Water Act, and other environmental protection statutes. But I wanted to ask you, prior to your current position, you worked as a lobbyist for energy companies while also advising the Trump campaign, is that correct?
Thank you for your question. I'm very proud of the work I've done as a private practice attorney. And I was, yes, a volunteer, as many lawyers do, for campaigns across the country. I exercised my First Amendment and constitutional right to volunteer for a campaign.
Absolutely, but you were a lobbyist for energy companies as well, is that correct?
I was a registered lobbyist,
Great.
yes, thank you.
Thank you, and in that capacity, you represented Southern Company, a utility company that generates a third of its power from coal, is that correct?
I'm not sure of the specific reference that you make there to the statistic, but I did work on behalf of Southern Company and a variety of other clients.
And in 2016, you referred to the Clean Power Plan and other environmental protections as, these are your words, contentious environmental rules that were the disappointment of many in the regulated community. Is that accurate?
I'm not sure where that quote comes from, but it sounds like something I may have said.
And do you believe that the purpose of environmental protections is to regulate entities? To please regulated entities, to please regulated entities?
No, and I don't think that's the context in which I would have meant that quote. I mean, clearly in this capacity as the acting Assistant Attorney General, my constitutional and statutory duty is to vigorously enforce the laws, and I think as my written testimony and my statement here today shows, we are actively and vigorously doing that across the full spectrum of our statutes, including the Clean Air Act and Clean Water Act and every other environmental and natural resources law. We have over 6,000 cases, matters, or appeals that are being really well handled by our team of over 400 career attorneys, and it's been an honor to work with them on that.
That's good to hear because it does concern some of us that the person that's the head of the EPA has actually sued the agency multiple times around these environmental regulations. So should environmental protections that are contentious, using your word, solely because they're unsupported by a regulated agency still be enforced? I just wanted to clarify that.
Oh, clearly, we enforce every lawful regulation and statute on the books, and we take that obligation very seriously. I do as well, and we will continue to do so in this administration.
Mr. Wood, I respect very much your work, and so please don't take this the wrong way, but there are some who have suggested that the appointment of a former coal lobbyist as the acting Assistant Attorney General of the Environmental and Natural Resource Division as a form of political patronage by the Trump administration in return for millions of dollars in campaign contributions by coal executives and companies to the Trump campaign. And I wanted to give you a chance to respond to that and tell us what you might say in response to many of my constituents who are writing to me about that specific issue.
All right, thank you. I'm very proud of the work I did in the private sector as an attorney representing great clients, and had the opportunity to work on behalf of those clients. And my work is a matter of public record with respect to the filings I've made. And those would reflect that much of my work actually was not in the area of coal, but more so in the area of nuclear. The only other thing I would mention in that regard is that upon my arrival at the Department of Justice, I worked with the ethics officials there and was provided an ethics opinion regarding my recusal obligations. As I mentioned, we have 6,000 or so matters, cases, or appeals. A very small number of those involve issues for which I would have had some involvement previously, and I'm recused from those, and I've abided by that ethics letter, and will continue to do so.
Thank you
for your
that.
question.
I appreciate that. I have just a few minutes left, so let me ask one more question. Under the Obama administration, the ENRD prosecuted several coal companies for violating environmental laws. For example, in 2015, Duke Energy pleaded guilty to 9 criminal violations of the Clean Water Act for a massive coal ash spill. Your predecessor, John Cruden, stated that this massive spill, and these are his words, was a crime and it was the result of repeated failures by Duke Energy's subsidiaries to exercise control over coal ash facilities. Will you and the ENRD prosecute similar violations of the Clean Water Act and other environmental laws so that we can be assured that communities in rural areas, urban areas across the country can be protected against things like coal ash spills?
Yeah, Congressman, thank you for that question. I can't speak to any specific case, but you have my assurance that the ENRD continues to vigorously enforce the clean water and clean air laws of the United States. We'll continue to do so, and I think my written testimony accounts for several recent examples in just the past few months where we are doing exactly that. But thank you for your question.
I appreciate that, and I can tell you that communities across the country, including in places like Flint, Michigan, and rural communities that are suffering with toxic situations and death in many of their communities, will be counting on you and your leadership to make sure that we continue to take this extremely seriously and prosecute violations of the law. Thank you. I yield back.
Thank you very much. The House has vote scheduled for 4 o'clock. That's an hour and a half from now. We're now an hour and a half into this 2-panel hearing, so we're kind of at the halfway point where we probably need to bring our second panel in. As much as I would like to do a second round of questioning with our distinguished panel, I do not think time will permit it. That being said, I would request that our witnesses entertain questions for the record that we will most likely submit to you, and if anybody has questions for the record, if you could get them to the staff within the next 5 legislative days, we will pass those along to you. And would y'all all agree to answer those questions? And,
Yes.
And we got affirmative from everybody on the panel. So with that being said, that will conclude our first panel. I want to thank y'all all for being here and for your testimony. And you are excused. We'll now call the second panel for today's hearing, and we'll give the staff time to set up, give everyone get time to get settled, give me time to freshen up, and we'll get going again here in about 4 minutes. The committee will come back to order. Get to bang here. I'll begin by swearing in our second panel of witnesses before introducing them. If y'all will all please rise. Do you swear that the testimony you're about to give before this committee is the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect all the witnesses answered in the affirmative, and y'all may be seated. Thank you very much. We've got another great panel of witnesses as we continue our oversight in the subcommittee. We'll start with Mr. Hans von Sprokowski. I'm going to call you Hans, even though I have met you several times, but your name is a mouthful even for somebody who has a radio background like I do. Hans is a senior fellow in the Center for Legal and Judicial Studies at the Heritage Foundation. He was a commissioner for the Federal Election Commission for 2 years, and prior to that, he was a career counsel to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. He's a former in-house counsel and also served in private practice. He's a 1981 graduate from MIT and a 1984 graduate from the Vanderbilt University School of Law, where my daughter is now attending. Go Doors. He published many articles, studies, and reports for the Heritage Foundation, National Review, Fox News, Wall Street Journal, and numerous other publications, and is a co-author of 2 books on election integrity and the U.S. Justice Department. Welcome, sir. Ms. Cleta Mitchell is a partner and political law attorney in the Washington, D.C. office of Foley & Lardner, LLP, and a member of the firm's political law practice. Ms. Mitchell practices before the Federal Elections Commission, the Ethics Committee of the U.S. House and Senate, and similar state and local enforcement bodies and agencies, and represents numerous candidates, campaigns, and members of Congress, as well as state and national political party committees. Prior to joining Foley & Lardner, Ms. Mitchell served as a member of the Oklahoma House of Representatives, where she chaired the Appropriations and Budget Committee. She also served on the Executive Committee of the National Conference of State Legislatures. As a University of Texas graduate, it pains me to tell you she earned her bachelor's degree with honors and JD from the University of Oklahoma. Andrew Grossman is a partner in the Washington, D.C. office of the law firm of Baker and Hostetler, where he practices appellate and constitutional law. He's also an adjunct scholar of the Cato Institute, a think tank, and writes frequently on the law and legal policy. He was previously a fellow in the Meese Center for Legal and Judicial Studies at the Heritage Foundation. Mr. Grossman earned his bachelor's degree from Dartmouth College and his master's degree in public administration from the University of Pennsylvania and a JD from George Mason University School of Law, where he graduated magna cum laude. Congratulations and welcome. Mr. Robert Weissman is the president of Public Citizen, the Washington, D.C. public interest advocacy organization. He is the chair of the Coalition for Sensible Safeguards, an alliance of more than 100 consumer, small business, labor, scientific, research, good government, faith, community, health, and environmental organizations united to protect health, safety, consumer, and environmental standards. Mr. Weissman has published extensively on issues related to corporate accountability. He's a graduate of Harvard College and the Harvard Law School. Each of the witnesses' statements, as with the first panel, will be entered into its record in the entirety. I ask y'all to summarize your testimony to fall within the 5 minutes that will be indicated on the clock in front of you. When it goes yellow, just like when you're driving, you speed up. Now you've just got 1 minute left. To conclude your testimony, when it's red, please wrap it up as quickly as possible. Hans, we will start with you.
Thank you, Mr. Chairman. The duty of the Civil Division is to defend the government, including its client agencies. Now, Rule 1.3 of the Rules of Professional Conduct of Lawyers in the District of Columbia also require a lawyer to, quote, represent a client zealously and diligently within the bounds of the law. Most importantly, lawyers may not intentionally, quote, prejudice or damage a client during the course of the professional relationship, close quote. Thus, Civil Division lawyers have a professional obligation and an ethical duty to defend the actions of federal agencies unless there are absolutely no circumstances under which they can be defended, a situation that occurs only rarely. Yet in a recent case involving the U.S. Election Assistance Commission, division lawyers violated that professional duty. In a lawsuit involving the federal voter registration form, civil division lawyers took the side of the plaintiffs and refused to defend the agency. EAC Chair Christy McCormick sent a letter to former Attorney General Loretta Lynch and Judge Richard Leon, who was assigned to the case, expressing her, quote, grave concerns regarding the potential conflict of interest and failure of the Department of Justice to provide, close quote, the EAC with proper representation. The Civil Division's erroneous claim that it could not defend the EAC were belied by the fact that Judge Leon ruled in favor of the EAC in his February 23, 2016 order denying a requested temporary restraining order. In his order, Judge Leon commented on the misbehavior of DOJ, noting that the division had taken, quote, the extraordinary step of consenting to plaintiff's request, not for a TRO, but for a preliminary injunction, exclamation point, close quote. He ruled for the EAC despite DOJ's failure to defend the commission. In fact, at that hearing which I attended, Judge Leon said he had never seen such behavior by a government lawyer in his entire experience as a lawyer or a judge. There was also evidence in the case of a serious conflict of interest because of lawyers from the Civil Rights Division taking over the decision-making regarding the main issue in the case, thus usurping the policy-making function of an independent bipartisan commission. The Civil Division was apparently so worried about this conflict becoming public that it asked for the deposition of Commissioner McCormick to be sealed. None of the lawyers involved in this violation of their professional obligations have been investigated or disciplined in any way. Second issue, and this has been mentioned by the chairman, one of the little-known costs for taxpayers is the judgment fund housed at the U.S. Treasury Department, a permanent, indefinite appropriation. This is used to pay judgments against the U.S. when it loses lawsuits, but it's also used to pay amounts negotiated by the Department of Justice, such as the Civil Division and the Environmental Division, to settle claims. Now, the Treasury Department does send a yearly report to Congress, and it maintains a web page, but the information provided is so limited that it's not sufficient to identify what the government did wrong and who's benefiting from these government payments. No copy of the complaint, judgment against the government, or settlement agreement is made available. All of this information could be easily supplied by the Justice Department's various divisions to the Treasury Department and made available for the public and members of Congress. The public deserve to know all the details of this, and this is the kind of transparency that we need. A third issue, an important issue in the International Refugee Assistance Project versus Trump case being handled by the Civil Division, is the issuance of injunctions by federal district courts with limited geographic jurisdiction that apply nationwide or globally to unidentified aliens who are not even parties to a suit. All of this violates a U.S. Supreme Court decision which the Civil Division, I don't think, has been asserting forcefully enough in all of its cases, called U.S. v. Mendoza. The key holding in that case was the usual rule of collateral estoppel that applies to private parties does not apply to the government. That means that the government has the ability to apply the executive order to individuals who are not actual parties to the litigation. One other thing that the Congress, I think, should consider, that is the chaos caused by having courts all over the country issue potentially conflicting and duplicative decisions on the same issue. I think you should consider saying that, or passing a law that says that any lawsuit contesting an executive order issued by the president has to be filed in the District of Columbia Federal District Court. This would prevent different cases, different decisions coming from all over the court, and there are precedents for this kind of action. Thank you.
Thank you very much. Ms. Mitchell, you're recognized for 5 minutes.
Thank you, Mr. Chairman, members of the committee, and thank you for the opportunity to appear here today. I'm appearing here today in my capacity as counsel to a number of organizations who were targeted by the IRS during the IRS targeting scandal, and subsequently in my capacity as counsel to one of the groups which filed a suit against the IRS because of the targeting scandal. All of those cases, there are multiple cases that have been filed by of different litigants that arose from the IRS targeting scandal. And all of those cases are defended by the tax division of the Department of Justice. And I'm here to talk about our experiences in 3 areas with respect to the attorneys in the Department of Justice Tax Division. In a word, the DOJ tax attorneys have done and continue to do everything in their power to stall, delay, and block the orderly proceedings of these civil cases and to throw every monkey wrench they can invent, devise, or imagine to keep these plaintiffs from discovering the truth and the facts that resulted in the intentional delay of the normal processing of hundreds of applications for exempt status by citizens groups solely because of their names and their missions. The DOJ tax attorneys argue at every turn that none of these plaintiffs are entitled to any relief, but it is not that I find so objectionable. What I find objectionable are 3 things I'm going to turn to now. The first is that I believe that it is the responsibility of the tax attorneys in the Department of Justice for the fact that the Lois Lerner emails were lost. At the time that our lawsuit was filed in 2013, and under the federal rules of civil procedure, under several federal statutes, the IRS and also the Committee on Oversight and Government Reform issued 2 subpoenas to preserve those documents, materials relevant to the IRS investigation, which were also under a litigation hold resulting from our lawsuit. And yet, imagine our surprise in June of 2014 when we learned through the media that supposedly Lois Lerner's emails were lost. We immediately sent a letter, which is attached to my testimony, to the Department of Justice tax attorneys and said we would like to immediately go to court or ask them to allow us to collectively, jointly, have an independent forensics expert team go into the IRS to see about recovering, locating, and retrieving these supposedly lost emails. They fought us at every step. They refused to agree to any kind of cooperative effort. We filed a motion for expedited discovery. They argued through the summer and ultimately prevailed, and no independent expert was appointed or allowed access to the servers, the backup servers, et cetera. And what we learned subsequently is that at the very time that they were objecting to allowing access to those servers, the servers were erased at the very time. And it also is absolutely clear that they took no steps when the lawsuits were initially filed to do what normal litigants do, which is to ensure that your clients are not doing anything to lose any documents, materials, or evidence. They even objected to the fact that we called it evidence. So I believe that falls squarely at their feet. And since that time, and separately from that, I've attached a copy of an order from the Sixth Circuit Court of Appeals in which the court castigated the Justice Department attorneys. The trial court castigated the Justice Department attorneys and said that their behavior with regard to discovery constituted studied obstructionism. It is fairly rare for an appellate court to call out the attorneys in a case, and in particular to call out the government attorneys. But that's what the Sixth Circuit Court did. These lawyers in the Department of Justice Tax Division should not be allowed to continue to engage in this misconduct. The trial court in Cincinnati said that what the IRS had done was being perpetuated by what their attorneys were doing. And they have applied different legal theories, completely taking the same legal theory and applying it in one manner in one of the cases and in another manner in other cases on whatever suits their purposes to try to obstruct and keep these lawsuits from coming to a conclusion. So I would argue that it is time for Congress to do something and that the administration should do something to bring these long pending lawsuits to a conclusion, which will only happen if the Department of Justice attorneys in the tax division stop obfuscating, stalling, and doing everything they can to keep it from happening. Thank you.
Thank you very much. Mr. Grossman, you're up for 5 minutes.
Thank you, Mr. Chairman. And thank you for holding this hearing today and inviting me to testify. My statement will focus on 2 issues concerning the Department's use of settlements to resolve litigation. One is the sue and settle phenomenon, and the other, which I will turn to first, is the department's new policy announced yesterday morning, generally prohibiting so-called slush fund settlements. The new policy is to be commended. As the subcommittee is all too aware, the previous administration believed that it could circumvent Congress's control of the purse by entering into settlements that required defendants to pay money not to the Treasury, but to third-party organizations. These organizations, including activist groups, were not parties to these lawsuits. They were not victims, and the money they received was not compensation or restitution or attorney's fees. This was pure programmatic spending of the kind that requires congressional appropriation. The previous administration's lawyers believed, incorrectly in my view, that they could skirt that requirement by diverting funds from entering the Treasury. The Attorney General's new policy puts an end to that sleight of hand. It bars the department from, quote, entering into any agreement on behalf of the United States in settlement of federal claims or charges that directs or provides for a payment or loan to any non-governmental person or entity that is not a party to the dispute, accepting restitution, attorney's fees, and payments expressly authorized by statute. So we should commend the Attorney General's action, but I will identify two respects in which it may fall short. The first concerns a particular type of slush fund settlement that draws money directly from the Treasury through the Judgment Fund Act to make payments to third-party organizations for programmatic activities. Now, if requiring settling defendants to make payments to activist organizations intrudes on this body's appropriations power, then taking the money directly out of the Treasury to pay for programs that have never been authorized or appropriated is an even more serious violation. Now, the poster child for this kind of abuse, as you all know, is the Keeps Eagles settlement that was recently the subject of a split-panel decision of the D.C. Circuit. I won't discuss the case because the subcommittee is well aware of it. But I will note that the Attorney General's new policy statement, at least as written, appears to be ambiguous on abuse of the Judgment Fund to make payments to third-party organizations. I understand that there may be disagreement within the department over whether such settlements should be allowed or not, although Mr. Riedler's statement on the previous panel seems to suggest otherwise. I think the subcommittee and the American people deserve to know with greater clarity what the department's position is on this important issue and whether the department believes that undertaking such payments is consistent with the governing statutory authority as well as constitutional authority. And I think they also deserve an answer to the committee chairman's letter regarding whether the department will act to claw back the extra Keeps Eagles settlement money for the benefit of taxpayers before it goes out the door. The second shortcoming of the new policy is that it ultimately does not bind an administration that does not wish to be bound. In my view, the Constitution and statutory law already prohibit these kinds of settlements. But when everyone gets bought off, there is no adversary to oppose an unlawful settlement. A simple fix is required, a simple statutory fix. Judges should not be allowed to approve these kinds of settlements, and the Judgment Fund Act should be amended to make crystal clear that it does not authorize payments to third-party organizations. This is required to prevent the gaming of our judicial system to circumvent Congress's power of the purse. Let me now turn quickly to the sue and settle issue. This subcommittee is certainly familiar with the problem, and so I won't cover old ground. We all know that agencies in the previous administration used collusive settlements to advance a regulatory agenda and to evade accountability. I can report that so far, we've not witnessed any of this kind of abuse by the Trump administration. In fact, EPA Administrator Scott Pruitt has declared that his agency, which was one of the worst offenders under the Obama administration, will not enter into settlements that set the agency's agenda. But EPA is only one agency, and I'm disappointed to say that the Department of Justice has so far been relatively silent on this issue. The proper policy for the department is not a mystery because it's the one that was actually identified on the previous panel by Mr. Wood. That is the policy that was adopted in 1986 by Ed Meese, Ronald Reagan's Attorney General. The policy is straightforward. Don't enter into settlements or consent decrees that convert discretionary authority into mandatory duty or that require the expenditure of unappropriated funds. If the Trump administration is serious about accountability, it should officially reaffirm the Meese policy. Action by Congress is also appropriate. As I explained in my written testimony, the Sunshine for Regulatory Decrees and Settlements Act, H.R. 469, adopts a thoughtful and comprehensive approach to this issue. More broadly, Congress should reconsider its use of aspirational and unrealistic statutory deadlines, combined with broad citizen suit provisions. As a matter of good public policy, a deadline that Congress does not expect an agency to meet is one that ought not to be on the books. And as a matter of constitutional principle, Congress should be the one enforcing rulemaking deadlines through its oversight and appropriations powers. Again, I thank the committee for the opportunity to offer these remarks, and I look forward to your questions.
Thank you very much. Mr. Weissman, you're up for 5 minutes, sir.
Thank you very much, Mr. Chairman, Mr. Johnson, for the opportunity to be here today. I wanted to speak broadly about issues related to corporate accountability at the Justice Department, including both criminal and civil enforcement with a focus on issues related to Wall Street crimes and wrongdoing. In 2008, as we all know, Wall Street crashed our economy, and we're still living with the after effects of that. Strikingly, the Wall Street banks and the financial sector generally was able to escape accountability for the widespread wrongdoing that occurred. There were effectively no criminal prosecutions by the Department of Justice, and no criminal prosecutions either of the largest banks or the executives at those banks who were responsible for devastating harm across the economy. We found out eventually that Department of Justice officials thought those institutions were too big to fail, too big to jail as well, too big to prosecute. Later in the Obama administration, there were a series of civil settlements reached with the banks, and those did obtain significant sums of money, but they were poorly executed. Those settlements did not disclose the underlying wrongdoing that the banks were alleged to have committed in some circumstances, and gave really no basis for assessing whether the settlements reached were correlated in any way with the impact and damage that the banks had had on the economy. There was a related problem that goes back far before the Obama administration that we saw, especially in the financial sector, but more broadly as it relates to corporate wrongdoers, which is the extraordinary use of deferred and non-prosecution agreements against corporate violators, as well as limited criminal accountability for corporate executives. It became the norm for corporations that broke the law to escape the requirement to plead guilty or to be convicted, instead entering into deferred or non-prosecution agreements that effectively amount to nothing more than a promise not to break the law in the future, which is a promise with no meaning whatsoever, since of course they're already obligated not to break the law in the future. As I discussed in my testimony, perhaps the most egregious instance involved HSBC for a massive money laundering scheme for which they were able to escape any kind of criminal liability. At the end of the Obama administration, in response to public criticism around these issues, we saw some slight change. Importantly, we saw the issuance of the Yates Memorandum with a focus on trying to prosecute executives at corporations that engaged in wrongdoing. We saw some notable criminal prosecutions involving Massey Energy and its executive, Don Blankenship, the Peanut Corporation of America, and a couple other notable examples. We also saw in the last days of the administration the settlement with Volkswagen, which both obtained substantial compensation, launched indictments against a number of executives and managers, and required the company to plead guilty to criminal wrongdoing. So we saw some progress in this area at the end of the administration. Unfortunately, in the early days of the Trump administration, signs are that things are going to reverse. Just recently, the Department of Justice entered into a non-prosecution agreement with Citigroup and another money laundering case. This is the Citigroup subsidiary in Mexico. Vast, for what the Justice Department called vast criminal wrongdoing, but again, no criminal prosecution, no criminal plea. It is a worrisome sign of a return to the bad old days. We've seen an astounding revolving door set of nominations for key positions in the Justice Department from the Solicitor General on down. And we've seen just earlier this week a move to deny justice for victims of corporate wrongdoing through Attorney General Sessions' newly announced policy to prohibit settlements payments to third parties. If you look at the actuality of those settlements, they are designed to ensure full compensation, full restitution for victims who often cannot be compensated directly. And I think this was an unfortunate move, which worrisomely may be a harbinger of yet more gentle treatment for large corporations. Corporate crime and violence inflicts far more damage on society, whether measured by dollars, injuries, or lives, than street crime, as horrible as street crime is. And it is absolutely vital that the Department of Justice take corporate crime and wrongdoing seriously, prosecute it fully, and also engage in aggressive civil enforcement. I think the early signs in the Trump administration are troubling about whether it intends to do just that.
Thank you very much, and we'll begin some questionings, and since there's nobody else on my side, I will kick it off. Mr. Spakowski, and I did get that right, I have a couple of questions for you. What's the scope of the duty of the DOJ to defend? Shouldn't they, when can they say yes, when can they say no to defending a government agency, and what's appropriate there?
The long-time policy of the Justice Department, and it doesn't matter what administration has been in the White House, the view has always been that it has a duty to defend all laws passed by Congress, even if the present administration might not like them, and also to defend all actions of agencies in the current administration, the past administration, with the only exception being, for example, when it comes to Congress, laws that infringe on the constitutional authority of the president, and with regard to agency actions, only if there is absolutely no reasonable way of defending the agency's action, and that almost never happens.
We have seen some issues where the Justice Department has not done that. Should the agencies be able to go out and get outside counsel to do that? What's the solution to that problem?
Well, that is a problem. The case, for example, that I mentioned in my testimony, in fact, when the Justice Department, in essence, told the U.S. Election Assistance Commission that they would not defend them, the chairwoman of that commission asked for permission to hire their own independent counsel to defend them, and the Justice Department, which has a say-so over that because the EAC has no independent litigating authority, said no. This was so disconcerting to Judge Leon that when the state of Kansas and the Public Interest Legal Foundation, which is a public interest legal, came in to intervene and say, well, if the Justice Department won't do its duty, we will defend the EAC. The judge did what is kind of unusual. He allowed them to intervene, and they actually defended the federal agency. It was the weirdest, most bizarre situation I've ever seen.
We saw a similar situation here in Congress. Should the Justice Department be required to enforce things like contempt of Congress or a subpoena for a congressional committee?
I certainly think they should, yes.
Ms. Mitchell, would you like to weigh in on that?
Yes, I would. I think that Congress should take steps to establish a procedure whereby it does not have to go to the executive branch. I think there's a serious separation of powers issue when the legislative branch of government is dependent upon the executive branch to enforce a subpoena issued by the legislative branch of government. I think there are ways that the House and the Senate could establish a rule and procedure through some of the ways that it has established litigation procedures in other areas, but I definitely think that this is a huge problem, and I think the Article I power of the Congress is at issue when you have the Department of Justice refusing to enforce a congressional subpoena. But imagine that this became particularly acute when you had the situation where the congressional subpoena was issued to the Department of Justice.
Right. All right, and you talked a little bit about the DOJ and tapes getting, or servers getting erased and tapes getting lost. If that had happened in a civil suit between private partners or private parties, there'd be a huge spoliation claim. And so why is the government different there?
It shouldn't be different, and I think that's one of the things that's really problematic with the Department of Justice and the Civil Division, particularly the tax attorneys. That's where I've had my experience, and I think that, you've had trial courts and you've had the circuit court both admonishing the DOJ attorneys, telling them to stop being so recalcitrant. If it were anybody else, these lawyers could be themselves personally subject to sanctions, and the parties entitled to damages. And it's just breathtaking to me that, the fact of the matter is those attorneys in the tax division should have taken immediate steps in May of 2013. They really should have taken them sooner, but in May of 2013, when all of these lawsuits were filed, they should have immediately taken steps to ensure that nothing happened to any backups, any servers, any emails, any documents, and they didn't do it.
And I'll have two quick questions for Mr. Weissman. Did you hear the chairman's opening statement quoting from the New York Times expose on the DOJ abusing the judgment fund to pay off allies over the vigorous objections of career prosecutors? And does that report trouble you? Microphone, please.
Yeah, I'm sorry, Mr. Chair. I have to say I'm less familiar with the judgment fund issue. I am more familiar with the issues related where the government is prosecuting the case, as the plaintiff in the case against corporate defendants.
All right, and just on a related topic, would it trouble you if the DOJ reworded donation terms and settlements to ensure groups of particular ideological stripes were ineligible for donations?
If groups, based on their ideology, were ineligible?
Right.
Sure, that would be troubling.
All right, thank you. I see my time has expired. I'll now recognize, would you like to go, Mr. Or Mr. Conyers? I'll leave it up to you two to decide which one goes first. We'll go to the ranking member of the entire committee, Mr. Conyers.
Thank you, and excuse my departures from time to time that are unavoidable. I wanted to start off with a public citizen's witness. The New York Times indicated only yesterday that officials across the government receive special waivers to disregard ethics rules. Did you happen to see that?
I did see that, yes.
And it offers additional evidence that lobbyists and industry executives have an unusual ability to shape policies benefiting their former clients and companies. So that sounds astounding to me. Can you help me feel more comfortable with this report?
No, I think your concerns are well justified, and that report actually is only a glimpse of the overall problem. The New York Times story was talking about the issue of waivers that had been issued, and after some considerable pressure, the administration had made available the waivers it's granted. There weren't as many as we might have expected outside of the White House. There were several extremely troubling examples from the White House. The reason the problem is worse than the New York Times story indicated is that it only related to the waivers. The bigger issue is the revolving door question, which I think is pervasive in the number of appointments that the Trump administration has made, and particularly is the case at the Justice Department, including in the example of the new nominee to run the Department of Environment and Natural Resources, the division, whose prior practice involved defending BP in the Gulf oil disaster, to replace the acting, who, as we heard earlier, has worked as a lobbyist for coal companies. That is emblematic of what's going on in the Justice Department and really throughout the government right now.
This becomes an incredibly important hearing, which I hope this subcommittee and its leaders will continue to press on even after this hearing. I think we've not stumbled on, but we've revealed a lot of things that most people, including members of the House, don't know are going on. And I appreciate this panel very, very much. Mr. Weissman, public citizen, was the financial crisis caused by fraudulently securitized mortgage investment packages caused in some way by the Department of Justice?
That was one of the main causes. The Department of Justice was not a facilitator of that. I would say a massive regulatory failure was. On the back end, I think since there was really massive crime and wrongdoing associated with those activities, we should have seen the department prosecuting people and corporations, and we did not.
What explains the dearth of the prosecutions of those involved in these fraudulent activities?
That's a hard question to answer. You know, I think one of the problems actually is the exact same revolving door story that we're seeing playing out on a worse scale now. We had high-level officials in the Obama Justice Department also come from the corporate defense bar, and I think they were very sympathetic to their former clients or companies that might have been their former clients.
So this had gone on before the present administration?
This is a problem that goes back as long as I know, actually. But I think we're seeing the worst we've ever seen in the Trump administration.
All right, I'll yield back the balance of my time, and I may send you some questions or comments that I'd like to check your reaction to them, and I thank the entire panel for their helpfulness.
Thank you, Mr. Conyers. We'll now recognize a gentleman from Georgia, the ranking member of the subcommittee, Mr. Johnson.
Thank you, Mr. Chairman. Mr. Van Spakovsky.
The Chief Justice Supreme Court also stumbled over it, so don't be embarrassed.
I would just go with Hans. Trust me on this.
I want to meet the challenge and get it right. But Mr. Van Spakovsky, as a member of the Federal Elections Commission, you were accused of politicizing your position, of being unacceptably partisan, and it was alleged that you consistently used your position to disenfranchise poor and minority voters. And it's also alleged that as an official of the Justice Department, it's that you advocated for the department to apply the Voting Rights Act of 1965 in a, quote, race-neutral manner, end quote. And throughout your career, it's been alleged that you have an obsession with the phantom and now debunked notion of so-called mass voter fraud, all with the aim of suppressing Democratic Party voters. What do you say about these allegations, and what is the Heritage Foundation's position insofar as the Russian attempts to influence the recent presidential election?
Well, I'm happy to answer those questions, Mr. Chairman, although they're not quite on the topic today. But I will tell you that those claims that you made about me are defamatory, libelous lies. And if you would like, I'd be happy to send you a copy of the 2013 report of the Department of Justice Inspector General, where he took a look at the cases that we handled at the Justice Department when I was there, and the conclusion of the Inspector General against those accusations that you have just made was that there was no evidence whatsoever that any of the cases that we handled were done in a political or partisan manner. And that is in the IG report. You don't have to take my opinion for it. As to voter fraud, yes, that is an issue I work on. On that issue, I'd be happy to send you a copy of the report that the Heritage Foundation has recently put together of close to 500 cases from across the country, 800 individuals convicted of voter fraud. I think that's something that we should all be concerned about when it comes to the integrity of the election process.
Okay, and the Heritage Foundation studies on the Russian involvement in the recent presidential elections, are there any underway thus far?
Well, I would cite to you the interview given by Jay Johnson, the Secretary of Homeland Security, during the Obama administration.
Heritage Foundation.
Yeah, well, I'm telling you that our view agrees with that of Jay Johnson, who said 1 week after the November election that there was no evidence of any kind that the Russians had hacked into either the voting process, the ballot counting process, or any of the actual voting administration process, and I agree with that.
All right, thank you, sir. Ms. Mitchell, isn't it true that no organization was ever denied tax-exempt status under the admittedly flawed criteria used by the IRS to process social welfare organizations for compliance with 501c4?
Mr. Congressman, I actually don't think that that is a true statement. I think that there are several organizations that were denied their tax-exempt status.
All right. And Mr. Grossman, in your written testimony, you state that the Justice Department should readopt the Meese memo, which restricts the use of settlement policy to circumvent federal statutes such as the Administrative Procedure Act. Are you aware that the Meese memo was codified in 1991?
Yes.
All right, thank you. Last but not least, Mr. Weissman, in your written testimony, you state that the recent Wells Fargo scandal, where the bank fraudulently transferred millions of accounts, raises both public and private enforcement questions. What effect does Wells Fargo's use of forced arbitration clauses in its consumer agreements have on the public's ability to hold the bank accountable for its misconduct?
Well, as you know, Mr. Johnson, this is a problem that's not unique to Wells Fargo. It's pervasive in the financial sector. The extraordinary misconduct of Wells Fargo, though, does throw into relief both the scale of the problem, its impacts, and how absurd it is that corporations are permitted to force victims into arbitration rather than into civil courts. In this case, because victims have been forced into arbitration, they were disinclined to bring lawsuits in the first place, and therefore unable to either join together in a class or engage in mass discovery that probably would have uncovered this problem earlier. With the problem now well known, Wells Fargo is still defending itself on the grounds that victims should seek compensation and remedy not in the courts and not through a class action mechanism, but through arbitration tribunals. That is to say, Wells Fargo is saying that victims who did not agree to have accounts created for them should be constrained by forced arbitration provisions in contracts related to other accounts they opened, not regarding these phantom accounts, which by definition they never contracted for. And nonetheless, Wells Fargo is making this claim, and given the state of the law, it remains to be determined whether or not they will prevail on it.
Well, they take that position because forced arbitration usually results in a decision in favor of the corporate interest. Is that correct?
That's right. These are tribunals that are stacked in favor of large corporations who are the repeat players and often have some influence over choosing who the arbitrators themselves are. They frequently make it impossible, the provisions of these contracts frequently make it impossible to join together as a class. Discovery is limited, and often the results remain secret so the public doesn't get the benefit of an open judicial system.
Certainly no record created, no right to appeal, no precedent or reliance on precedent in the decision-making, no reliability for the consumer, other than the fact that the deck is stacked against them.
Exactly so. We refer them to them as rip-off clauses or get-out-of-jail-free cards for large corporations.
Thank you. With that, I yield back.
Thank you very much. And as we've been through a round of questionings, and Mr. Conyers has, I believe, gotten y'all all to agree to respond to any questions for the record, I think it gives us an opportunity to conclude today's hearing, and I want to thank you.
Mr. Chairman?
Yes, sir.
May I have unanimous consent to put in to the record the New York Times article dated June 7th, lobbyists were granted.